5, 4, 3, 2, 1. Mzansi, don't worry about a thing, 'cause every little thing is gonna be alright. Welcome to another episode of The Dissection. Many things have changed since Jerome Kwanazi held that press conference on Fiasco Sunday, Conundrum Sunday, Crinkum Crankum Sunday. We heard on Wednesday that the crime prevention wardens, Amapanyaza, are going to be a thing of the past. And Panyaza Lesufi, the premier of Gauteng, made some strategic moves, which made it seem at some point as if, he was doing this of his own volition. A public protector report then came out later in the evening. Nonetheless, this is something that Jerome Kwanazi also testified about, that in the meeting of the provincial commissioners and the national commissioners, he had actually raised the issue that Amapanyaza were unlawful. So another one bites the dust. And in fact, I probably should have started this episode with another one bites the dust. Another one bites the dust, because people are biting the dust. People are biting the dust, and many things are happening. Now there's been a new development. Another person is potentially biting the dust. Think about all of the different people who have taken special leave or had to do some dust biting as a result of everything that's played out. General Shadrack Sibia had to take suspension. Mr. Senzo Mkhunu is on special leave. And there's been a new development. The Chief Justice has suggested that Judge Audrey Ledwaba has been told or encouraged to take special leave. And he has refused, and he said he wants to tell his side of the story at the commission. And I think if he goes to the commission, we may have another one biting the dust. Another one biting the dust. So let me give you the context and tell you where this is coming from. Late last night, we saw a statement from the Chief Justice, Mandisa Maya, on behalf of the judiciary on the testimony at the Madlanga Commission. This is what the statement said. The judiciary has noted with great concern the testimony given on 21 October 2025 by one Witness A at the Judicial Commission of Inquiry into Criminality, Political Interference, and Corruption in the Criminal Justice System, known as the Madlanga Commission, to the effect that he heard from an informer that a sum of 2.5 million was earmarked to secure bail for Mr. Katiso KT Molefe, although the witness did not know if this money was intended for the presiding judge, the acting judge President Ledwaba, or the public prosecutor. This testimony, an allegation yet to be tested and proven at this stage, still has the potential of damaging the integrity of the judiciary, and we reiterate a plea which the judiciary has issued on numerous previous occasions, that any person who has evidence of a judge's misconduct must promptly lodge a complaint against that judge with the Judicial Conduct Committee, the JCC of the Judicial Service Commission. The JSC is the constitutional body with the lawful mandate to investigate any alleged misconduct by a judge, and in terms of the provisions of the Judicial Service Commission, Act 9 of 1994, recommend the suspension of the judge to the president, who is the functionary with the power to suspend a judge in terms of the Constitution. The process of the JSC is triggered by a formal complaint on oath, which has not been done in this case. The Chief Justice has, however, discussed the matter with Ledwaba, including the possibility of granting him special leave pending the finalization of the Madlanga Commission. Ledwaba, acting judge president, who strenuously denies receiving any money to grant Mr. Molefe bail, has indicated that he will not take special leave, which a judge may not be forced to take and has to apply for voluntarily. He has also indicated that he is seeking legal advice and expressed a wish to be afforded an opportunity to give his side of the story at the Madlanga Commission. The judiciary acknowledges its obligation to ensure that appropriate action is taken expeditiously where any judicial officer is found to have acted unlawfully or unethically, and reasserts its commitment to its duty to serve all South Africans with impartiality and integrity. They posted this statement. That's where it ends. They posted it on Twitter. They closed the comments. And people on Twitter are like, open the comments. Knock, knock, knock. Open the comments. We want to kuluma with you. We want to engage. Closing the comments is often a bad decision to take on social media. It's never the direction of any entity that seeks to engage the public. It's more like, we're talking to you. Don't call us, we'll call you. That's really how it comes across. Reading this statement carefully and rereading it, I actually picked up that Justice Mandisa Maya actually is trying to tell us something. She's trying to tell us something, but let me first give my thoughts. I'm going to get to what she's trying to tell us. Before we do any of that though, have you subscribed? Not subscribing is Hosh Kari behavior. It's Hosh Kari behavior to not subscribe. This channel is dedicated to looking at these big topics, dissecting them, helping you think through them, pointing out interesting views, perspectives, and all of that. And some people are threatening us. They are saying, hey, take down this thing, take down that thing. Listen, we're going to continue doing the dissection. The least you can do is make sure that you're subscribed, you turn on your notifications, you're commenting in the content section, share this with your WhatsApp group. Let's try to reach 125 before the end of November, or 130. Let's aim for 130. Let's be ambitious. 130 before the end of November. Let's push. Let's see if we can get to 130,000 subscribers. We recently crossed 120,000 subscribers. Thank you so much to everybody who's subscribed, who's supporting the channel. I really appreciate you. And I appreciate your prayers and everything that you've been doing, to give me strength and solace as we are facing these threats that are coming from wherever. But also, I'm going to be taking all of the precautionary measures that are necessary. I recently got the email address of the National Commissioner, Fani Masemola. I'll be writing him a letter about some of these threats, the intimidation, the harassment, and giving my view. And I think also attaching an affidavit to that. I think that will be the first step, because he will know and maybe suggest where best to direct this. And I've also spoken to some of my friends who may or may not know members of parliament, etc., to see what can be done at that level. So it's not something that I'm taking lightly, and it's not something that I'm going to just dismiss. But we've also not been given a spirit of timidity. With no spirit of timidity, no weapon formed shall prosper. We shall continue to dissect. Free speech, Baba, freedom of the media. Let's go. So here are my thoughts. The judiciary is in an interesting time, globally and locally. In the USA, there's increased awareness of how the ideology of the Supreme Court justices can affect decisions and the role that the selection of judges plays in shaping the country and the rule of law in that particular country. That's why you're seeing, debates about should there be more justices added, how to deal with the selection of judges in a way that makes sure that there's ideological balance in the Supreme Court of the USA. One of the most lasting decisions or effects of the Trump presidency is that he will have chosen a large number of judges who will continue to affect American society in a variety of ways through their judgments. That's America. And you've seen that conversation. It's happening in public. There's no one saying, no, judges matter. Just don't ask. Don't ask about judges. No, people are saying we must ask, we must scrutinize, and I think that's justified to do. In Africa, particularly in the dictatorships, if you're talking about Cameroon, Robert Mugabe, Zimbabwe, it was long known that the dictator can influence the courts, and that judgments on issues pertaining to the regime or to the interest and preferences of the regime are often in favor of the regime. If you challenge and say elections were rigged, you're going to lose that case. If you come and try to challenge Robert Mugabe, you're going to lose that case. Very rarely would people win those cases. And I think there's an acknowledgement and understanding that dictatorships can influence judges. And if you can appreciate that dictatorships can influence judges, and that in democracies like America, judges can also be chosen in ways that produce outcomes that benefit one group of elites or another, I don't think you should be dismissive of the same nature of argument in a democracy, even South Africa. I think that there's room to think about whether or not the judiciary is always serving its purpose and working in the interest of the public, or if there are instances where criticism is justified. In South Africa, there's been a growing whisper of dissatisfaction overall, people respect the judiciary, they respect judges, and that has continued to be the trend. Law students, we are always told, hey, judges are up there, boy. You know, like in basketball, you got Michael Jordan. Law students have got different judges at the top. You know, they'll have their judge of preference that they admire, often a constitutional court judge. And you have to choose one who is very, very, very respected by other peers. And, you know, you have to show a certain deference to judges. And that's justified, you know. But at the same time, there's been a growing whisper of dissatisfaction with some of the judgments which have been made, particularly those concerning issues affecting the highest seat in the land, the political games that have been playing, the Game of Thrones, contestation for the seat for the highest office. I must say, I disagreed with the decision of the court in the Zuma imprisonment judgment, you know, that judgment June 2021. It's my view that they should not have heard the matter as a court of first instance. I think that matter should not have been taken by Zondo to the Constitutional Court. I think that in and of itself was something that should not have been done. Number two, it's my view that they should have gone with the coercive order rather than the punitive order, because it was in the interest of justice for Zuma to actually testify at the Zondo Commission and complete that stage of that process. And the coercive order gives the respondent, and just to explain the distinction between the coercive order and the punitive order, the coercive order gives the respondent the opportunity to avoid imprisonment by complying with the original order and desisting from the offensive conduct, which is walking out of the commission, etc., right? Because an order was there that Zuma must go. So that coercive order, right, is made primarily to ensure the effectiveness of the original order by bringing about compliance. Right? The punitive order, the characteristics of the punitive order are that a sentence of imprisonment cannot be avoided by any action on the part of the respondent to comply with the original order. So what Kampepe J said in that judgment was the following. She said, I consider a punitive order to be the appropriate sanction because I am alive to the reality that there's simply no hope remaining that Zuma will attend the commission. I disagreed with that statement and that argument because it's prophetic. No judge is a prophet. There's no prophet judge. There's prophet Elijah, prophet so-and-so, no prophet judge, right? The justice system works on actions which have been taken, not actions predicted. We wait for people to do something, right, wrong, whatever, and then we evaluate whether or not that action was justified, legal or illegal. We do not say, that says a or to translate, this one is about to steal. Then we come and we arrest you, say, you're about to steal, gonna arrest you. We arrest you for an attempt, we arrest you for stealing. But just if you're sitting on the sofa saying, iPhone 17, I must Zama something, that in and of itself is not enough for us to say, no, you are guilty, go to jail. Right? So I disagreed with this prophetic approach. You cannot imprison someone on the assumption that they will not comply to the order. It slows down the process, but you cannot fast forward it. I felt that there was an attempt or a wish to fast forward the process, get to the point where Zuma is imprisoned so that they can finally be this. Zuma has been held accountable for his actions as president. This was not the way to do it. The legal system can be slow and it should move faster. And in many other countries does move faster. But be that as it may, this I thought was not the right way to get accountability if any was necessary. So I disagreed with that decision. Further, at paragraph 56, she said the following. However, I'm alive to the fact that the case before us is so markedly distinct from any matter that has preceded it that it exceeds the expectations of legal precedent. The result is that despite my efforts, I found very little solace in our jurisprudence. The extent and the gravity of this contempt of contempt in this matter is singularly unprecedented and absolutely inimitable. She's, number one, saying, I cannot find jurisprudence that supports my argument. I cannot find precedent. And precedent is important in law. It's very important. You have to base your decisions on prior decisions and the reasoning of prior judges. You cannot always just freestyle. So she's saying, I can't find anything to support me. But Zuma is so extraordinary. the level of delela that he has shown us is so extraordinary that we're going to do something special for him, just for him. That made me uncomfortable. That made me uncomfortable. At paragraph 57, she said, I acknowledge that the decision at which I arrive, namely an order of direct committal, may constitute an unprecedented step forward on the trajectory of contempt litigation. At paragraph 58, she says, I acknowledge that for the most part, our jurisprudence has left me up the creek without a paddle. She's saying, I can't find support for what I'm saying. And those concessions to me were significant because I was like, nope, I don't think you should take such an extraordinary decision with the implications that it has on the basis of a projection of Zuma's future behavior. I didn't like it as a line of reasoning, and I disagreed with it. Two other judges also disagreed with that decision and penned a dissenting judgment, namely Jafta J and Theron J. I say all of this to make the point that there has been some criticism of judgments and judges which cannot merely be wished away, and I think is at times very legitimate and cannot be dismissed merely by saying, judges matter, Baba. No, I think there's more nuance that is required to the conversation than that. There's also been criticism of judges themselves. We have seen the criticism of Dr. Madlanga, which led to his removal. In that instance, it was okay to criticize a judge and say this conduct is not within what is expected of a judge. That's what we were told. We've seen the criticism of Eastern Cape Judge President Benenge, who was soliciting nyash from the office. He says in his flowery way of saying it that his soliciting of nyash in the office was welcome. It was not unwelcome. That's his argument. We've seen criticism of him. We've seen criticism of the judge who was drunk driving through walls. So we understand that some judges can be political. We've said that of Dr. Madlanga. We've seen criticism of judges saying judges can be horny. We've seen that with Mbenenge. We've seen criticism of judges that they can be drunk, right? We've seen that. So we can't make the argument that judges are angels handed down to us before Jesus left. I don't think that's a real thing. There has been some serious criticism of one judge in particular. I'm not going to tell you his name just yet. Wait for it. In 2021, there was an interesting exchange in the interviews for the Supreme Court of Appeal. Then Supreme Court of Appeal President asked a certain judge 3 questions. Number 1, why was he submitting judgments late and submitting judgments which his peers said were of inferior quality and had to be rewritten? Number 2, why did he go against clear precedent set by a full bench in a case where he was sitting as a single judge? Number 3, if he was a corrupt judge. This judge asked him to his face, are you corrupt, Wena? I have to ask you because you have a dark cloud. Just listen to the exchange and observe who the judges were.
I'm not sure about the appropriateness of my next question, and you don't have to answer it. But I'm going to put it out there anyway because I've been directly confronted about inviting judges who have dark clouds hanging over their heads to act at the SCA. Now, this is about these allegations that have been, doing the rounds on social media and elsewhere for a while now about the so-called CR17 records that you allegedly improperly ordered to be sealed. Would you like to comment on this? In fact, let me just ask you a straight question. Are you a corrupt judge as some have painted you?
No, President. On this matter involving the CR17, the so-called CR17 matter, I called all the parties for a meeting, and there was an issue as to whether that envelope should be available, the contents thereof should be available to the public or not. And I was also told that some of the information in the envelope involves third parties. This was not a court, it was just a meeting in my office. So I ruled that since there's an issue and interest of third parties are involved, I did not even see the contents of that envelope because it was sealed by then. I ruled that if any party is of the view that it should be available to the public, I'm willing to manage the matter and to allocate a date of hearing to the parties so that the matter can be argued in court. And that is a step that the parties took, and the matter has been before the court. I think judgment has now been reserved as to whether the contents should be made available to the public or not. So I failed to understand why there were rumors that I did not make an order that the contents of the envelope should be made available to the parties is because I was protecting my colleagues or I was protecting the president.
Honorable Malema.
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Commissioner.
What is the procedure? The procedure is such that a person can write a letter to you to seal documents without any court hearing, and you seal them, and you want to open them through a court hearing when you have not sealed them through a court hearing. Because in this instance, there was just a letter where there was an indication that there's sensitive information, third parties involved, and you sealed it. And then for you to open them, we had to go to court. But for those who wanted you to close them, they didn't go to court. Like you just said now, it was a discussion in the office, and then the documents were closed. So I want to understand, what is the procedure? Do you, for documents that are submitted to a public court, for them to be sealed, are you not supposed to make an application for such documents to be sealed? So that when now there's an counter to that, it can also be made in a public court to argue why those documents should not be sealed.
I listened to the evidence presented by Witness A and Witness B. I listened to the amount of evidence that they had, which placed Katiso Molefe at the center of the issues pertaining to the killing of Armand Swart. Personally, I would not have granted Katiso Molefe bail, which is what Judge Ledwaba did. It raised a lot of questions. And it raises even more at this point, where we've been hearing about the work of syndicates in manipulating the system to get bail. I don't think those criticisms are unfair. And I think often people know, prosecutors know, police officers know how the system is manipulated. And when they share that information, I think we ought to listen to them and take what they are saying seriously. I mean, let's think about what was said and what was presented. For instance, Michael Puletau said he needed to get external medication and medical attention for his diabetes, when the reality is that it can actually be managed from prison. And when he got bail, he violated the terms of the bail. He was going to work in his own version. That's what the Sun said when Witness B went and looked for him. And if Witness B was not vigilant, he would have been continuing with what he described as work. Remember when they caught him there after the murder of Armand Swart, he said he was on duty. But he wasn't on duty for the public. He was on duty for particular interests. So if you consider what we've been hearing, I think that we have to take seriously what people are saying about the problems in the system. Now, let's look at the facts in the Katiso Molefe case. The fact that he was in the vehicles, which were scouting outside QTech, making calls, receiving calls. His iPhone is not a phone that someone else could have just opened and unlocked and be able to receive calls on his behalf. He went to the workplace of Armand Swart, was part of the scouting. The fact that he was visited by Michael Puletau multiple times, the fact that he was asking his girlfriend Lirato for details about the targets, the fact that his nephew was the buyer at Transnet, all of these things are indicative that he played a role in the murder and he most likely was the paymaster. The fact that payments were made from him to the hitman, the fact that he has a prior conviction for drugs and for illegal possession of a firearm in the UK, the fact that he has been in possession of multiple identity documents, the very serious nature of the offense, and that the offense was committed in a premeditated nature by a syndicate of people in furtherance of other criminal activities alleged, namely the obstruction of the fraud at Transnet, makes this a Schedule 6 offense. In light of all of that was presented, I would have been very, very compelled to deny him bail. And I would have if I was sitting as the judge. The magistrate did, but Ledwaba did not. And recently another judge did not. And I don't think that there is a rational basis for that decision. Let me explain Schedule 6 offenses. Schedule 6 offenses are considered the most severe offenses. They can include crimes like premeditated murder, attempted murder, repeated sexual assault, one of which include where the death of the victim was committed by a group of persons or syndicate acting in the execution of the furtherance of a common purpose or conspiracy. Typically, bail is not granted for these types of crimes. Section 60.11 of the Criminal Procedure Act says, notwithstanding any provision of this act, when an accused is charged with an offense referred to in Schedule 6, the court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused has been given a reasonable opportunity to do so and adduces evidence which satisfies the court that exceptional circumstances exist in which the interests of justice permit his or her release. I don't believe that Katiso Molefe presented anything exceptional except to say that he wanted to go finish business in Velcom where he's applying for another tender. I would have actually just blocked him from even doing that because we all can see that there's serious Hosh Kari behavior that is happening there. So I wouldn't have granted him bail. Now, when I look at the statement of the Chief Justice and look at the video that I played you earlier, I think she's actually between a rock and rockets. A rock and rockets. It's hard either way. Rock, rockets. Because one will fire you up, boom. The other one will just, that's what I think is happening here. I think she does want to fix the issues in the judiciary. And there are many issues which need to be fixed. For instance, the late judgments. Let me tell you a little bit about these late judgments. As of August 2024, more than 220 judgments were outstanding for more than 6 months. Within the Joburg Labour Court, the Pretoria High Court, the Mahikeng High Court, all of these having the highest numbers of late judgments. The number of late judgments has more than doubled since 2019, when around 90 were recorded. So it went from 90 to 220. That's a serious issue which needs to be addressed. People are still asking the serious question, where is that judgment, that Phala judgment from that case we all saw last year? It's been over a year now, I think. Right? So people are asking, and that's a real question. In this instance, though, I think that she's kind of on the right. I'm going to side with her. I'm going to tell you why. I think she wanted the public to know that she's tried. And I think when you look at that other video, you can see that she's not impressed with Ledwaba at all. She's tried. And she's tried to do what she can to hold this judge accountable without there being a formal complaint. She's trying to get him to take a timeout. The president could suspend him, but I don't think he's going to do that because of that CR17 issue. And, he was helped in a way. Whether it's not a direct conflict or whatever, he benefited from those records being sealed. It just prevented certain levels of scrutiny. I also think she understands that she still has the duty to uphold the stature of the judiciary and to defend judges from unfair criticism, which is why the statement sounds defensive in parts. But I think she was trying to tell us that, hey, I tried. And now as a result of those actions, Ledwaba is going to go and speak at the commission. I think they'll take his request to speak there. And if he wants to speak, let him speak. Let us hear what he has to say, right? Ultimately, the judiciary does have to be proactive. I don't think a defensive posturing is going to be sufficient at this point. I don't think they can keep saying to everyone, just lodge a complaint, just lodge a complaint. Some people don't have the resources to do that. Some people are afraid to do that because of the nature of the issues. And General Mkhwanazi has lodged a complaint, a public complaint, on behalf of everyone. Right? We heard what General Bheki was saying yesterday about issues within the judiciary that he's observed. Right? So at this point, some proactive action needs to be taken by the judiciary to restore credibility and their image, because that is part of how you keep rule of law in a country. The judiciary has no army. It has no army, and it relies on the respect and stature and adherence to their judgments by the public. But more and more, if the public feels like you're not doing your part, they'll walk away from everything. I want to close off by saying this. All men are flawed. All men, women too, are all flawed. Even the Hosh Kari mamas, They are flawed. That's why they have to go and become Turkish delights in Turkey, that side, to try to hide delights, that they don't delight in. All men are flawed. And that applies to judges too. There's no holy person called judge who is given to us by the Archangel Gabriel at a certain moment, right? These are human beings, mere mortals. We are all mere mortals, right? That's why you must question everything, examine everything, and apply tools of critical analysis and thought, right? All men are flawed. So that's number one. Number two, there's always room for improvement. We can't approach anything as if the judiciary is perfect. No room for improvement here because it was perfect since 1994. I don't think that's true. All institutions must be open to re-examination and sharpening the saw and removing the hubris within themselves internally and making sure that they can adjust to the needs of society and, just making sure that they can maintain their credibility. There was an outlet that I used to enjoy eating meat at, Shisanyama. When they started, the meat was so delicious, the portion so generous, so large, 100 rands, you'd be full for 3 weeks. 3 weeks, 100 rands. Then at some point, they started reducing the chuck portions and the Vos portions, and everything just shrank and shrank and shrank and shrank. And that franchise basically is a bust now. I don't think there's a Chisanyama anywhere, right? Because they didn't uphold the quality of their product. You need to uphold the quality of your product. You need to re-examine, sharpen the saw, seek to improve at all times. I don't think the judiciary is exempt from that. And let them use this moment for proactive reflection, introspection, and improvement. That's my thought about this moment. I don't know what you guys think. Let's have a conversation in the comment section. I'll catch you there. I'm still going to do the witness B summary. I think it was very important. This just popped up and I thought, let me cover this first. But the witness B summary is still en route. Wait for it.